All right. Good evening, everyone. Welcome back. I was just saying prior to starting the recording that if folks will be concluding their time with the fellowship before the final session, which is scheduled for Monday, April 24th, please let me know in writing so that I can anticipate class attendance for some of our future sessions. That'd be greatly appreciated. In anticipating the end of the semester, recognizing that we have now entered April, wanted to remind everyone that the deadline for final papers is Friday, April 14th. So that is next Friday. So please get those into me as soon as possible. I know I spoke about this with one fellow, but to make it as clear as possible, these final papers will also be used to create a bridge for subsequent fellows from your school so that they have an understanding of the work and research that you have done, as well as an understanding of where they may pick up if and when they carry on the torch. So know that you are writing it for me as well as your supervisor, as well as subsequent fellows, so that we can ensure that there is no ball dropped as students transition out through their term of the fellowship. As well, in looking at the data upload, as well as the document upload in the shared folder, I'm not seeing many lines highlighted. And so wanted to revisit this ask for everyone that it is imperative for each of you as fellows to go into that shared folder, review the information for all of the categories reflected. So this includes attorney research, campus police, civic leaders, courts research, highway patrol, local police, office of the sheriff, politicians, and state police departments. So the ask was for everyone to review the information from their jurisdiction in all of those categories. I think some folks may have thought that it was choose one rather than doing all of them. So wanted to provide that reminder that that information should be reviewed and updated, and once completed, highlighted so that I know that it has been finished and is ready for upload to the consortium's website. If you have any questions about that, as usual, don't hesitate to let me know. I have also scheduled an office hours for this Thursday afternoon, and recognizing those have not, I won't even say have been sparsely attended, those have not been attended for previous sessions, wanted to ask those in attendance this evening if that is of value, if I should keep that on the calendar, or if folks prefer just reaching out to me when they have questions. Let me rephrase. Would it be of value to retain that on the calendar?
I feel like yes, but at the same time, like, I don't want to say yes because I don't know for sure that I would. I don't know. It's probably one of those weird, like a safety net, knowing that it's there, but you don't know if you're going to use it. So then maybe out of respect for your time, if it's not being highly attended, then I'm fine reaching out with any personal questions I have.
Okay, I appreciate that. All right, I will go ahead and cancel it and appreciate the conversation in the chat. And as well, if there are things that you want to share about, like struggles that you have encountered in your research or partnerships, I'd encourage you to use the Discord channel for that, so that it can also be shared across the network. I always love receiving that information, but I think it's of additional value to ensure that it's received by the rest of the class. So thank you for that insight. With that, this evening, I am delighted to be joined by Randall Ravitz, who is the General Counsel for the Massachusetts Peace Officer Standards and Training, also known as POST Commission. Before joining the POST Commission, Mr. Ravitz was an Assistant Attorney General and Chief of the Appeals Division in the Criminal Bureau of the Massachusetts Attorney General's Office. Serving under 3 attorneys general, he has successfully argued before courts at all levels of the federal and Massachusetts judicial systems, including the Supreme Court of the United States. He's also a National Association of Attorneys General Supreme Court Fellow and a recipient of his office's Attorney General Edward W. Brooke Award for Excellence. Mr. Ravitz, thank you for being with us this evening. And I know you mentioned some of your colleagues may be joining as well. If you want to allow them an opportunity to introduce themselves if they're here.
Sure. Carrie Johnson, are you available to speak? Can't hear you yet.
See, she's unmuted.
Okay, so that might not be working, but
Fine.
Elizabeth Smith.
Hi, can you guys all hear me?
We can.
Okay. My name's Elizabeth Smith. I actually started at the Post Commission 3 weeks ago. I'm a paralegal and hearings administrator, and I'm just here to listen in on Randy, and he's great with the Post Commission. So you guys will.
You broke up a small bit at the end, but thank you for joining us.
It's too bad. I like what she was saying.
Thanks for having me.
Thank you.
Great. Well, Randy, thank you for being with us this evening. I want to give the floor to you.
Thank you very much. I have a presentation to share. Okay. We should all be able to see that. Is that right?
We can indeed. Yes, thank you.
Okay, thank you. I've entitled this Improving Law Enforcement in Massachusetts, the Legislature's Vision and the Work of the New Post Commission. And let's start in the most logical place with the sweeping criminal justice legislation that the Massachusetts General Court, as we call it here, enacted in 2020, which established the Post Commission and included a number of other measures. And it was entitled An Act Relative to Justice, Equity, and Accountability in Law Enforcement in the Commonwealth. Now, there are a number of people involved in developing the legislation. It was a collaborative effort among a number of different interests and incorporated a lot of measures that had been proposed over time and that were put together when the time was right. One of the leading groups was the Black and Latino Legislative Caucus within the legislature. And then there were senators such as William Brownsberger and Sonia Chang-Diaz and Representatives Claire Cronin and Carlos Gonzalez, who were instrumental in securing the passage of the act. And then Governor Charles Baker, now president of the NCAA, not only signed the law, but had a role in what it looked like, in that he proposed certain changes that the legislature ultimately adopted. Now, there were a number of themes in the legislative history, and this is based on the speeches given on the floor of the Senate and House, all of which are available online and can be viewed. And it's based on an analysis of draft legislation and a statement by the governor, as well as certain publications that were put out by key sponsors. And they reflect a balancing of multiple themes, objectives, and principles. And we remain mindful of all of them. We see our mission as being to give effect to the legislature's intent and all the different parts of that, all the different interests that it sought to balance. So one was supporting law enforcement. And the legislators said in their comments that the service and sacrifices of officers are appreciated and that they believe the overwhelming majority of them had good motivations to do their jobs well. And that agencies and officers can benefit from better training, from consistent high standards, and from greater collection and dissemination of information that could, for example, help them to hire better people for their own agencies. And that could help them become more effective and to generate more confidence in law enforcement and keep the public safe. So it was to support them. But another theme was that misconduct by officers, and in particular misconduct that raises issues of racial justice, needed to be addressed. They said that there's a small percentage of officers who have engaged in misconduct even to the point of demeaning, injuring, or killing members of the public. Such officers, they said, destroy trust between law enforcement and communities, they harm other officers, and they render the public less safe. And communities of color have suffered in particular. More must be done, they said, to further racial justice. And the killing of George Floyd, which had just happened that year, and surrounding events, put that in stark relief. They also thought it was necessary to address very specific forms of conduct. And that included the use of deadly force and other force, which they thought needed to be restricted and monitored. And the use of specific devices, such as firearms, rubber pellets, stun guns, chokeholds, which they banned outright, tear gas, pepper spray, other chemical products, and canines. They also said that officers must intervene when they are witnessing a misuse of force by others, and that conduct reflecting bias or dishonesty warrants special consequences and monitoring. At the same time, the legislators wanted to provide for serious consequences for misconduct, but only after fair adjudications. They said that when officers are accused, they should be judged through fair processes protective of their rights, and there must be mechanisms to suspend them, retrain them, and even remove them from law enforcement in serious situations. And that process should begin with internal agency action. They also thought Massachusetts should be communicating with other jurisdictions regarding the decertification of an officer, which is a concept I'll talk about in a little bit. Additionally, the legislators called attention to youth interactions with the criminal justice system. They said that more must be done to prevent young people from winding up in the system. A repeated refrain was that the school to prison pipeline needs to be addressed. And police involvement in schools and the exchange of information between police and school officials needed to be controlled. So here's what they did in their sweeping legislation. One big area was that they regulated the conduct of law enforcement more than it had been. They restricted the use of force by officers and potentially dangerous techniques, such as the ones that I mentioned earlier. They required officers to intervene when force is improperly used by others. They restricted the use of facial recognition technology. They limited the exchange of information between officers and schools regarding students, as I said a moment ago. They banned racial profiling. They prohibited officers from having sexual relations with those in custody, and they restricted the use of no-knock warrants. They also provided direction regarding the oversight of law enforcement personnel. And they did that by, for example, establishing qualifications for cadets, for officers, and for the state police colonel, the head of the state police. They required new forms of training to be completed. They prescribed procedures for officers to be promoted and for them to be disciplined. And they revised the state program governing school resource officers, which I'll talk about in a minute. They also required added forms of data collection and reporting. And they wanted to facilitate the public's ability to obtain information and relief in certain specific ways. So they included provisions that enhanced access to information about police, that made it easier to secure civil rights judgments against officers, and easier to have criminal records expunged. They also created a whole series of special commissions to study and propose recommendations regarding various areas that they saw as being important to look at more closely. And that included commissions on the status of African Americans, Latinos and Latinas, persons with disabilities, Black men and boys. Those are all 4 separate commissions they created. A commission to deal with school resource officers and their relationships with the municipalities they serve. Another commission to look at correction officers and juvenile detention officers and when and how they use force and their oversight. So that could, for example, lead to a commission like the one that we have for law enforcement officers that I'll talk about in a moment. Another special commission on facial recognition technology. A commission to look at emergency hospitalizations of people when there's a likelihood of harm based on mental illness. A commission to look at civil service and personnel administration and hiring in parts of government. A commission to look at a law enforcement cadet program, and another one to look at structural racism, well, actually to look at structural racism in correctional facilities, the parole process, and the probation service. And finally, one to look at qualified immunity. And we think that the jewel in the crown in this legislation was the creation of a permanent new agency to oversee law enforcement, entitled the Massachusetts Peace Officer Standards and Training Commission. That's the agency that I serve. And they wanted that agency to be given a broad range of authority with respect to law enforcement officers and law enforcement agencies. They wanted it to be independent from any other branch of government. They wanted it to have a civilian majority, and that's something that, according to the sponsors, set this agency apart from similar agencies in other states. They knew that. They wanted it to be different than comparable agencies in other states in that respect. And they wanted it to collaborate, and this was something that the governor cared a lot about, with a separate agency called the Municipal Police Training Committee, which continues to be under the governor and the Public Safety Secretariat under the governor, and that generally has primary responsibility for overseeing training programs, designing them, developing the curriculum and requirements. Now, I'll give a greater overview of the new agency, the Post Commission. Here's what the structure looks like. It has 9 commissioners. 3 of them need to be law enforcement officers, 6 need to be civilians. So again, a clear majority civilians. 3 are appointed by the governor, 3 by the attorney general, and 3 by those 2 jointly. And there are provisions in the statute that provide for diversity in terms of gender, race, geography, party affiliation, professional background, and nominating entities. Then they also provided through the legislation for an executive director and a staff. And as a result of the combination of the new law and existing laws, the commission needs to engage in regular meetings, at least on a monthly basis, which must be open to the public. The legislation also provided that no civilian commissioners or the executive director or certain enforcement personnel could have previously been employed in law enforcement and still work in those positions within the Post Commission. They gave the commission broad powers. They said it shall have all powers necessary or convenient to carry out and effectuate its purposes, including but not limited to, and then there's a long series listed in the statute. A lot of those are things that, powers that are given to every agency, but a lot of them are not given to every agency, such as the ability to compel certain action by officers and law enforcement agencies, to demand records and testimony, to assess fines and fees, and to remove officers from the profession of law enforcement permanently. And those powers are further discussed in the sections that I'll be addressing next. Now, where is the agency in the process of building its structure now? Well, we have now 6 divisions and 29 employees, and that's expected to grow significantly in the next few months. We all work under a terrific executive director. The commission has held 35 of those public meetings. We continue to expand our infrastructure by building out new technologies, by securing larger office space, continuing to hire more people. We have developed a whole series of regulations and policies, and I can say very sincerely that the people who work for the commission, the commissioners themselves, and the colleagues of ours in that other agency, the MPTC, which oversees training, are dedicated. We work well together. There's been a very high level of cooperation, so that even though people are coming from very different backgrounds, the commission includes police officers and somebody who sues police officers. They all work very well together. And that has created, I think, for better policymaking. Now, one of the large areas of responsibility that we have is the certification of officers and agencies, meaning law enforcement officers and agencies. Just to give an overview, our commission and that sister agency of ours must establish certification requirements that include a whole series specified in the statute. Certification is required for appointment or employment as an officer by a law enforcement agency. Now, officers who are already serving were given automatic initial certifications with staggered expiration dates. So the first third of the alphabet got 1 year, the second third got 2 years, the third got 3 years. But otherwise, a certification is good for 3 years at a time. And here are the requirements in the statute for officer certification. Somebody needs to be at least 21. They need to have graduated high school. They need to complete basic training. They need to pass a physical and psychological fitness evaluation and pass a full background check that includes an employment history. They need to pass an approved examination, have current first aid and CPR certificates or the equivalent. They need to submit to an oral interview, complete that. They need to be found, and this is a big one and one that's been the topic of a lot of discussion. They need to be found to have good moral character and fitness for employment in law enforcement. They must never have had a felony conviction. They must not be listed in a national or state database with names of decertified officers. And also, it must be the case that while previously employed in law enforcement in any state or United States territory or by the federal government, they would not have had their certification revoked by the commission if employed by an agency in the Commonwealth. Now, I'll talk about the process of certifying officers. Really, that has proceeded through a combination of things that have actually worked well together, even though this is the first time they've been deployed. One is a set of regulations, protocols, and advisories that we developed governing the process. Another thing is the enlistment of agency supervisors to assist. So we basically charged supervisors within law enforcement agencies to take certain steps and report certain information to us. And then we designed information systems to process all the information that we're getting on these thousands of officers. And at the same time, we gave officers the opportunity, if they got an adverse decision, to get review by our executive director, and even more review through a hearing before the commission if they're discertified with the decision. The legislation also provides for the commission to issue a specialized certification for school resource officers. Now, the school resource officer program is itself a balanced one. It aims to promote school safety, but at the same time while respecting the distinctness of the school environment. So the program is governed by a whole set of parameters and provisions that allow for police to be in schools on request and to perform certain functions, but at the same time limiting their role and making sure that they cooperate with school officials so as not to disrupt the school environment. The responsibilities for that program are divided among a number of state agencies, as well as local agencies. And the legislation provided that in order to be a school resource officer, an officer has to get a specialized certification from our commission. Additionally, the legislation provided for us to certify agencies, law enforcement agencies, working together with our sister agency that oversees training. And those standards need to address at least 8 specified areas: use of force and reporting of it, officer code of conduct, officer response procedures, criminal investigation procedures, juvenile operations, internal affairs and complaint investigation procedures, detainee transportation, and the collection and preservation of evidence. So where do we stand with all that? Well, we've adopted regulations and protocols, and we are considering a whole series of others that will further round out how these processes work. Our agency has certified or recertified about 9,400 officers, conditionally certified about 230 officers. So we basically said, you're almost there. If you can complete these requirements within a short amount of time, we'll certify you. If not, I'm afraid we can't. That's basically what we said to them. And then there have been hundreds, or I'd say approximately 300 officers. I don't have the latest figure in front of me, but about around 300 officers who were not certified. We held our first hearing recently regarding a denial of recertification, and we're now addressing recertification for the second third of the alphabet, as well as developing plans for the agency certification process. Now, the next large area within our charge is enforcement of the statute and disciplinary action. The legislation highlighted certain forms of conduct that the legislature wanted us to take action upon finding. So in other words, these are the forms of conduct that you see referenced most prominently in the statute. One is criminal conduct, another conduct leading to injury or death, conduct involving the using or failing to report of excessive force, conduct involving bias, and those involving dishonesty. And what are the forms of disciplinary action that we can impose? Well, in certain cases, we are required, in other cases, we're allowed to suspend an officer's certification, to order the officer to undergo retraining, or to be decertified. We can also refer officers to other offices, other entities of government, for criminal or civil action to be considered by them. And then there's also the potential that we can impose assessments, fees, fines, penalties, and sanctions. We're given those powers, and possibly other forms, because again, the grant of authority under the statute is so broad. But there are procedures that need to be undertaken. First, it's expected that the agency itself, the employer, will investigate the matter and submit reports to the commission in accordance with its regulations. Then we have the ability to examine records, issue subpoenas, examine witnesses under oath. We would, in many cases, conduct a preliminary inquiry, which is a confidential by statute investigation. And then there would be a hearing before the commission in most cases before or shortly after some form of discipline is imposed. Now, I've mentioned a number of times the concept of decertification, and I just want to elaborate on what that is and just how serious it is. If somebody is decertified, so not just if they didn't get certification, in which case they could come back and try again, but if their certification is actually revoked pursuant to the process that I've described after a hearing for serious infractions, that individual is then barred from applying for training or certification, or from working for any law enforcement agency, or for working for a sheriff's office, or from working for the public safety secretariat in any capacity for life. So it's a very serious consequence. Then in addition, we need to report that person to a national database and work with other jurisdictions, the statute says, to ensure that they're not hired there. Also, we have to publish the order of decertification and enter the fact that the person was decertified in our own public-facing database. And that individual cannot challenge any resulting employment consequences with the State Civil Service Commission. And there are separate provisions of the statute that give them increased exposure to civil liability for whatever the conduct was once they've been found to warrant, once decertification has been found warranted. So where do we stand with all of that? Well, we've there too promulgated regulations regarding how agencies need to handle and report complaints and related information regarding our own adjudicatory processes. We received about 1,500 complaints last year. So far, we've suspended the certification of 22 officers. And this, keep in mind, we only started taking those actions a few months ago. And this is maybe a strange way of phrasing things, but if you look at the agendas for commission meetings, there are references to 16 preliminary inquiries being considered by the commission or placed before the commission for consideration. Why do I phrase it that way? Because our statute requires that preliminary inquiries are confidential. So instead of saying how many have been initiated. I'm going to say how many times that question has been put before the commission, which is something that we disclose in the meeting agendas for commission meetings. And further actions are expected, so keep an eye on our website. Another major area that we're charged with addressing is the collection and analysis and dissemination of information on officers. Starting with the collection and analysis of information. We were directed by the legislature to obtain historical disciplinary record information, complaints, and investigative reports regarding officer alleged misconduct, to receive information on the extent to which they've satisfied training requirements, and to collect and evaluate reports regarding certain uses of force. We're also charged with maintaining an internal database with various forms of information on officers relating to their certification, training, termination or other separation, complaints, allegations of untruthfulness, disciplinary matters, and criminal charges. We are also expected, based on a combination of different provisions, to analyze data regarding misconduct and to give attention to patterns that we see. And what do I mean when I say we're expected to do this based on a combination of provisions? Well, there are some, there's one provision that states that we have the power to promulgate regulations for identifying patterns of unprofessionalism, including those regarding escalating behavior that could lead to excessive force or biased conduct or increases in the frequency of complaints or higher number of complaints. So it gives us the power to do that, basically suggesting that that's something the legislature would likely want us to do. There's another provision providing for us to monitor our own disciplinary database to identify patterns of unprofessionalism and then consider recommending one of those preliminary inquiries. Another provision allowing us to refer patterns of racial profiling or mishandling of complaints to other enforcement authorities and to impose discipline based on patterns. So in other words, again, a number of things in the statute that tell us we should be analyzing the huge quantity of data that we get, looking out for these patterns. And all of that is in addition to obtaining information regarding very specific matters as part of investigations that we conduct when we look into close certification matters or disciplinary matters, as well as any times when we might audit agency records going forward. Now, what about dissemination of information? Well, the statute provides for us to maintain a public-facing database with information on officers and disciplinary actions against them, to publish the significant decisions on our website, to provide information to, again, this national database that deals with decertified officers and other jurisdictions, as I mentioned earlier, and to refer cases involving agencies mishandling complaints, patterns of racial profiling, and other misconduct to other authorities who might consider criminal and civil enforcement action. And it also provides for us to submit annual reports to the legislature, governor, and attorney general. So where do things stand regarding that category of functions? Well, we've collected disciplinary records from the 438 agencies that we oversee. We've received information on training from our sister agency. We've published and reported information on certification and disciplinary action, and are coming out with more information on a pretty regular basis. We're soon going to complete promulgating regulations concerning our databases and dissemination of information that aim to balance the need to put that information out there with other state privacy laws. And we're developing improved processes for collecting information on things like uses of force and injuries and deaths. We also continue to improve our technologies and the integration of information so that all of this can be combined in a seamless way. So when you type in an officer's name in a database, you can find out all about them. And then another area is the regulation and oversight of day-to-day activity by officers and agencies. So not just how they get into the profession and how they get out of the profession, but what they do while they're working. And so one area within the statute that's really fleshed out is the use of force. And the statute provides, and our regulations say this as well, that force shall not be used unless de-escalation approaches have been tried and failed, or they're not feasible and they're necessary and proportionate. That deadly force shall not be used unless there's also imminent harm. That officers are barred from employing certain practices like chokeholds or restricting breathing or blood flow to an individual's head or neck. Again, let's not forget this legislation was right in the wake of the George Floyd killing. And that certain crowd control practices may be used only in certain situations, or that they're otherwise restricted, and that agencies have to develop plans for crowd control when they know that they're going to be encountering that situation. That officers have a duty to intervene, I mentioned that before, and that various forms of information have to be reported by officers within their own agency or to our commission or to another type of national database that's been developed for that purpose, and that officers need to be able to do that without retribution. Now, another area regarding this category of day-to-day activity concerns in-service training. And statute provides that we can, if we encounter that an officer has not completed their in-service training requirements, we can administratively suspend them. And it says here, failing to meet them, but I meant failing to meet them. And that we can do that through a process that's easier than it is than other disciplinary processes, but it's also easier for the officer to get the administrative suspension lifted. All they have to do is satisfy those training requirements. Then agency record keeping is another day-to-day activity that can be regulated through and overseen through auditing of books kept by law enforcement agencies by the commission. But those are the only areas where the statute really provides a good amount of detail regarding this regulation of day-to-day conduct. There are other provisions of the statute, again, that give us broad powers, and they're stated in very general ways. So the commission presumably has the ability to oversee and impact day-to-day conduct by law enforcement officers and agencies in various ways, but the statute doesn't spell those out in detail. And so that's something that we've begun talking about. We've started off focusing more on the things that the statute was really detailed about, and the things where they gave us deadlines. And now that we've begun addressing those things, and those things are more functioning on their own, we started to look to these other areas, think about these other areas where the statute wasn't as explicit and how we might impact them. So that's part of where things stand right now regarding this area of regulating day-to-day activity. When it comes to use of force, we've promulgated regulations, and we're in the process of developing more policies and processes for collecting information. We issued advisories on related topics, and we've administratively suspended around 50 officers who didn't complete their in-service training based on the records we had. And we're developing regulations dealing with the auditing of law enforcement agency records at the same time that we look for patterns. We look for things that we see that might generate ideas for other ways to regulate and impact day-to-day officer conduct. So that concludes my presentation, at least the formal part of it. And I would be happy to entertain any questions that people might have. I hope that was informative.
Randy, that was super useful. Thank you so much for that overview. An initial question that I have, recognizing that we have one fellow in attendance today who is a student at Suffolk. However, the majority or all of our other fellows represent 18 other states, as well as the District of Columbia. Wondering if you can tell us a little bit about how the formation of the Massachusetts post learned from the posts in other states, recognizing that there is one in each of the other 49.
Right. Well, that same question I saw posed to one of the key sponsors, and he said, well, we didn't, I'm paraphrasing, but we didn't really model it after any particular state. Instead, we put together a whole series of provisions that people here in Massachusetts thought should be included. Now, having said that, I mean, as you said, all these other states have post commissions, and a lot of them call them the post commission, the Peace Officer Standards and Training Commission. So there was, to some extent, some process of looking at other states. It's just, as far as I can tell, there's no one or two states that were clearly the model. One of the things that we want to do more of, and that on some level has been a challenge as we've been growing, as our staff has been limited, as we've first been building the agency, but that we are doing more and more of, and really want to continue doing more of, is to thoroughly analyze what these other states are doing, get any ideas we can from them, see what works and what doesn't. For those of you who have ever been asked in your career, academic or professional, to do a 50-state survey of anything, you know that it's a big undertaking, but it is something that we would like to do more of.
I appreciate that, and also provided as a bit of a prompt to our fellows to, where appropriate, engage in some research around what your local post may be undertaking.
Yeah.
And Abby, recognizing I reached out to you earlier, and as our fellow from Suffolk, wanted to give you the right of, I guess, apologies at this point, it is second response as I had a first question, but want to give you the floor if you have anything to share here.
Not a problem. Thank you so much for the presentation. It was super informative, but I'm gonna let other folks that have specific questions join off and hop in first.
Great. Holly?
Thank you so much for this presentation. It's been absolutely fascinating. Kind of two questions. In discussing qualifications for officers, are you aware of like college credit or associate's degrees being considered? I know that some individual departments require an associate's degree or like 60 college credits, but I didn't know if that was discussed or if that just wasn't feasible for an entire statewide policy. And then second question, when hiring officers from out of state, how does the process differ when you're hiring from a state that reports these officer disciplinary issues versus states that don't?
Yeah. Well, the first issue regarding higher education as a requirement, it's something that comes up from time to time, and different people have very different views on that. And one way I know recently that it came up is we've been talking about regulations, as I mentioned, for this specialized certification to become a school resource officer. And someone suggested that, and there were some different views on that. And then I know just recently, I can't remember where it was, I saw an article about that subject where I think it might have been an opinion column about how higher education should be required for to become certified as a law enforcement officer. It's something that we're aware of, that we've heard discussion of, but that our commission has not yet really gotten into that issue, or gotten into the process of seriously debating whether or not to add that as a requirement. But we would have the power to do so if people found that to be warranted. And then the other thing was about people from other states. So there's a few things. One is one of our requirements for certification is that the person must have passed a background check, a state and national background check, it says, and that if they've ever worked in law enforcement before, we need to get their full employment history and examine that. Another thing that's in the statute is, I mentioned this national database. I didn't refer to it by name, but it's called the National Decertification Index. And it's not the case that every jurisdiction participates, but many of them do, and they upload information on officers who've been decertified. And under our statute, if somebody is listed in that database, they cannot be certified by us. And so that would be a way that we would become aware of and take into account what has happened in other states. But I know that what you're talking about is something that legislators and others have been concerned about, and they are right to be concerned, because other than that National Decertification Index, there isn't any kind of comprehensive national database with everything you'd want to know about law enforcement officers. So on some level, it's up to our jurisdiction, our commission, to do its homework, and other jurisdictions to cooperate with us.
Thank you.
I'm happy to share additional information on the National Decertification Index for those that are interested as well. That's an initiative run by IATList, which is a group that we have explored some partnership with. I'm only purely going on order on my screen. So I'm going to go Katie, then Lakshmi, and Stephen. So Katie.
Hi, thank you so much. This is a great talk. I really appreciate it. I have two questions. One, I was curious as to how certification and decertification intersects with local hiring. So I used to live in Massachusetts, and in our town, I think that city council had a role in police hiring, which I think in recent years has become like very politicized. And so I'm curious, that's my first question, is just how does certification intersect with that? And then my second question is about school resource officers, and it was just whether Massachusetts has issued statewide guidance on the status of school resource officers as school officials versus law enforcement, and how that factors in.
Yeah. Okay, so first issue, certification and decertification, how it affects hiring. And I'll also throw in suspension, because I think it's an interesting issue. If somebody needs to be certified in order to work as a law enforcement officer, so if they're not certified, and they haven't been decertified, they're just not certified as a law enforcement officer, they could still work as a civilian for a law enforcement agency, but they could not work in a job that basically looks like a police officer to all of us. They need to be certified in order to do that. Okay. If they're not certified, doesn't mean they can't work in any way, in any capacity. If they are decertified, so again, not just that they haven't satisfied all the requirements, but we have revoked their certification for some serious reason, they are, by statute, they are barred from working in any capacity for any law enforcement agency in Massachusetts, any sheriff's office, or any agency within the public safety secretariat, and there's no time limit on that. So we view that as a lifetime bar, and even it says even as an employee or even as an independent contractor. It's very serious. So, but then suspension, if their certification is suspended, some sponsors got this question during the process and in other forums. Well, what exactly does that mean? And what they said was, well, that doesn't mean that the person necessarily has to be fired, but they can't. There was a phrase that was used in something I heard where I think they said they can't carry a badge and gun. So there are some other references in surrounding areas of the statute that deal to performing police duties and functions. So what we've understood that to mean is, all right, if somebody they're certified as an officer, now their certification is suspended. It's not fully taken away, but it's suspended. They cannot perform police duties and functions. It doesn't mean they need to be fired. It's up to the local agency. Local agency could continue to keep them as an employee, but they cannot act like a police officer. So that was your first question. The second question was about school resource officers, and the school resource officer program has been around for a while, but it has evolved. When it was first created, it was largely in response to school shootings and things. So it was very much focused on safety and reducing gun violence, things like that. And schools were required, or school systems were required to have them. In 2020, with this police reform legislation, they decided they were going to basically roll it back somewhat. Not completely, but somewhat. They were going to add in more balance, take into account some of the complaints about the ways that it could impact the school environment. And so they said, all right, we're going to make it optional. If a school superintendent or school district requests it, then they get a school resource officer. And there's this whole series of statutory provisions. I think it's chapter 71, section 37P of our general laws. And and it spells out, all right, there needs to be a memorandum of understanding, and there need to be operating procedures. And those things need to include all these different things. And one of the things is what you referred to in your question, which is there needs to be a provision in there that says these school resource officers are not disciplinarians. They are, I would like to actually get that quote in front of me, but it would take me a minute to look it up. But there is, something that needs to be that needs to be included in this memorandum of understanding that says that expressly, and they need to adopt a memorandum of understanding pattern after this model in order for somebody to work in that role. So does that answer the question?
Yeah, I just put in the chat. Could you say again what statute of Mass General Law that's in? What part?
I think it's chapter 71, section 37P.
Thank you.
Lakshmi.
Thank you for a very insightful presentation. I have two questions. One, I want to know in terms of the collection and the dissemination of the information you gather. I want to know how often do certain activities of misconduct have to appear before they are considered patterns of misconduct, and what factors do you use to assess the formation of patterns? Is it more frequency, or is it a time frame? And the second question has to do with decertification. You mentioned that decertification increases officer exposure to civil liability, and so I was wondering if officers aren't decertified, what types of general protections do they have from civil liability?
Okay. So, all right. So the first question was about patterns, and to be perfectly candid, that's something that we're still figuring out. So far, we don't have, excuse me, a definition of what a pattern means. How many incidents, how close in time they have to be, how serious they have to be, how related they have to be. We don't have a formal definition of what a pattern is. That is something, though, that we're discussing all the time. And I said I literally just came out of a meeting where we were discussing that topic. And I think that one place to look is other statutes and regulations that also deal with patterns of conduct. So, for example, in the harassment context, you see that concept. That doesn't mean that they'll necessarily fit in this context. Also in racial profiling, this area is developing. So it doesn't mean that, again, that necessarily any place else where we see this can, being grafted perfectly onto our area, but it's helpful to look at other areas and how they define a pattern. But it is something that we're continuing to figure out. And for that reason, if anybody has any ideas, send them to us. And that goes for anything really. And I'm sorry, the next, what was the second question?
I was wondering about how decertification, you had mentioned that it increased exposure to civil liability for the officers who are decertified. So I was wondering, in circumstances where decertification isn't involved, what is the extent to which police officers are protected against civil liability?
Well, one of the ways is through qualified immunity, and that's been the subject of a lot of discussion, as people know, nationally. And okay, I'll just read the section of the statute that I had in mind. It says no law, it defines bias-free policing, and it says no law enforcement officer shall be immune from civil liability for any conduct under color of law that violates a person's right to bias-free professional policing if said conduct results in the law enforcement officer's decertification by the Post Commission. And so what that means is that when there's another form of immunity, such as qualified immunity, that protection is no longer available if the officer was decertified for the same conduct. Does that answer the question?
Oh, I was wondering, in terms of when they aren't involved in decertification, when that's sort of off the table,
Yeah.
how, to what extent? Because before decertification, there's probably other levels of misconduct, different severity that don't rise to the level of decertification. So before that, I was wondering how protection from civil liability plays into that protection.
Well, it would really be, I think that the principal doctrine that officers would invoke would be that doctrine of qualified immunity, which largely turns on, and I'm just paraphrasing here, the extent to which the right at issue or the law regarding the alleged violation of the right, the extent to which it was clearly established at the time. So that's, I wish I had a better definition right in front of me, but that's largely what it turns on, is the extent to which the law was clearly established at the time of the conduct. And so officers can benefit from that in certain circumstances. I think not as much as people think. Some people think that means that officers can, do whatever they want. That's definitely not the case under qualified immunity. But, again, as I was saying, that that and any other immunity would be limited where the officer is decertified. By the way, I also have in front of me just that language that I was mentioning regarding school resource officers, and it says the model memorandum of understanding, and again, the localities need to adopt their own memorandum of understanding that's patterned after the model one that was developed by a special commission, that it shall expressly state that school resource officers shall not serve as school disciplinarians, enforcers of school regulations, or in place of licensed school psychologists, psychiatrists, or counselors, and shall not use police powers to address traditional school discipline issues, including nonviolent disruptive behavior.
Thank you.
Stephen?
Good evening. Thank you very much for your presentation and for the work that you've done, sir. I had 3 questions. I'll make them quick. Let's see. With the amount of exodus from law enforcement and how desperate law enforcement agencies are, we're seeing in a lot of jurisdictions sort of a watering down of the standards. And with this, you're really tightening them up. So I wonder how much pushback there was from the agencies at large. The second question is, do you have any control or authority over reserves or auxiliaries? And lastly, you had mentioned chokeholds are essentially prohibited. Is there an exception for chokeholds when lethal force is in fact authorized? Thank you.
Thank you. Let me see, I'll start with the last question, if that's all right. There isn't an exception written into the statute regarding chokeholds. So the statute says a law enforcement officer shall not use a chokehold. And then it says a law enforcement officer shall not be trained to use a lateral vascular neck restraint, carotid restraint, or other action that involves placement of any part of the law enforcement officer's body on or around a person's neck in a manner that limits the person's breathing or blood flow. So there are other forms of deadly force that are allowable by law under the statute and regulations in certain circumstances, but that one has basically been taken off the table. Now I was gonna go in backwards order. So could you just remind me the second question?
Yes, sir. Not a problem. Let's see here. Reserves and auxiliaries. Do you have any authority over them?
Yes, but here's the statute in the definition of law enforcement officer. So basically that, in a way, that definition governs who's subject to our jurisdiction. It says, or it ends with the phrase, or any other special reserve or intermittent police officer. But at the same time, that itself, that phrase can raise questions about what that means. And so what the commission has said so far is that it's looked at the way very similar phrases have been interpreted by our courts in other contexts. And they've been interpreted as referring to temporary or part-time officers. And because it uses the term police officer, which has a special meaning in our case law. So not every law enforcement officer is necessarily a police officer. Police officers have greater powers of arrest. And because it comes at the end of a series of definitions, and there are canons of statutory construction. I think it's pronounced, what's the canon? I think it's pronounced ejusdem generis. That, basically you interpret that last thing in the series as being similar to the things that come before it. The commission has looked at all that and said, all right, what that phrase means is we're talking about part-time or temporary officers who perform police duties and functions and who are otherwise similar to the other things on the list. So that's the way it has been interpreted. And part of the reason for even engaging in that exercise is because not even the term reserve officer, I guess, is less unclear in Massachusetts law, but the term special, there's a decision on the books that says that term special officer has been used in all different ways. So that was part of the impetus for putting that interpretive question before the commission. And I'm sorry, your first question was?
Yes, sir. And if I just might follow up with the reserves then. So reserves are in fact then, they are available to be decertified, although are they really certified? I guess is kind of the point I was getting at. But first question is with the limiting of people that are going into law enforcement or the exodus, every law enforcement agency that I know is pretty desperate to hire people. So with this initiative, you're really tightening up standards. Have you gotten much pushback from the agencies throughout the state?
We've gotten some pushback, some complaints, but I would say by and large, not as much as you might think, given that a profession is subject to a whole series of new regulations and strict oversight. I mean, I think that, there have been a number of officers and particularly leaders of law enforcement agencies who have said to us, this is helpful to us. We can benefit from this. This will help us to ensure that our own agencies and officers achieve high standards. So there are a lot of people in the law enforcement community who are supportive of this. And also we tried to get the message out there that our goal is to be fair, to take into account different points of view, not to end anyone's career where it's not justified or where there hasn't been a fair set of procedures. I mean, we really want to take into account all the interests of people inside and outside of the law enforcement community, and come up with things that are sensible and just.
Thank you very much. I appreciate the answers.
Thank you.
Jaden, I saw a few questions from you in the chat, acknowledging one has been answered, but want to give you the floor to ask the others.
Yeah, sure. Thank you. And also thank you, Mr. Ravitz, for the presentation. Thoroughly enjoyed it. And I'll kind of follow up on the first question, which was both of them really were dealing with the increased exposure for officers. And when you reference the what the statute provides for when decertification follows, and I was just kind of wondering, those are actual state causes of action that can be, say, for instance, pled supplementally in federal court, along with federal causes of action that might exist for those kinds of constitutional violations that, in federal court, qualified immunity would take care of and probably knock out in a lot of situations, unfortunately. But I guess I was basically wondering if this statute provides for state causes of action that, qualified immunity couldn't necessarily touch, and that if I brought in federal court would be reviewed a little bit differently.
I think it's possible that a federal court might not consider itself to be impacted by these provisions of state law. So if someone brings a civil rights action under Section 1983 in federal court, they might the federal court might look at our statute and find that it doesn't impact the way that the federal court will review the matter. But there are a lot of things like that. Really, honestly, there are a lot of issues that we're seeing involving the fact that all of this is potentially governed by multiple agencies. So, there could be a matter that comes before a federal court or a state court or the Civil Service Commission or an arbitrator, that could be governed by a collective bargaining agreement. There are all these different, potential authorities that could end up with concurrent jurisdiction over matter. And it has yet to be seen how all that's going to play out. Yeah. And even, in the legislative debates, there was a question like that. And one of the sponsors said something similar, like, the question was about concurrent investigations and things. And they said, well, that happens a lot in a lot of situations. And, we're trusting these agencies to work together and figure it out. Yeah. But it remains to be seen, I think.
Yeah. And that's helpful. And I guess I was thinking more about, like, if I were bringing a 1983 action, say in Massachusetts, against an officer, could I also, is there something in the statute that allows me to say, plead supplemental state law claims under under the post statute, that the federal court wouldn't be bound by like the federal doctrines of like qualified immunity and things like that and so then would allow me to where qualified immunity would knock out the federal action, I will be allowed the state cause of action under this statute if I was understanding increased liability or increased exposure to liability correctly.
Yeah, I get what you're saying, and I think it sounds like what you're envisioning is, let's say, something that involves it's in federal court, involves a 1983 action, but then there's also an action for violation of the state civil rights statute.
Right, exactly.
And then, invoking this provision that I referenced to help continue pursuing that state civil rights action.
Right.
Let me, I guess I'll just say, I understand the theory, the line of reasoning. I'm because it's something that I haven't, analyzed exactly. Yeah. I'm wary to say exactly how it's going to play out, but I understand where you're going with that.
Awesome. And and maybe that'll come in handy one day. Hopefully, we'll see. But and my second question was dealing with the so with increased exposure, right? And people harmed under this, potentially wanting to recover under, if there's a state cause of action in the statute, wanting to recover. Were there any conversations about like requiring as a requirement for certification being, having that liability insurance for when that increased exposure, if increased exposure does land, that folks are able to recover? And the reason I ask that is because Raleigh, that's where I'm at actually, Raleigh, North Carolina. Raleigh recently, Raleigh City Council voted on a city measure that would do that for Raleigh Police Department. And so I was wondering if there was any considerations of that or debates about that in the legislative history or anything like that.
I don't remember that coming up. I think it's an interesting issue though, but I don't remember that coming up.
Awesome. I mean, I have one more question. If I'm not sure if anybody else did, but yeah, I have one more question regarding the commissions that were several commissions. I was wondering if so like with several different commissions, I noticed it was African American, and then it was also Black boys and men, which I thought there was some value in that. I was wondering though if there was any talk about any kind of bureaucracy or any kind of like with different people, different groups that might be focusing on similar issues, if there were any complaints about, not being sure who to report to about what and that kind of thing.
So is it, is your question about basically about where people would bring their complaints about officers?
Basically if there was a problem between, if the commissions basically could work together on things, or if there might be, because I definitely obviously within Black boys and men and African American generally and that kind of thing, or if there was like if it was more collaborative effort or kind of siloed.
Well, those special commissions were almost all in the nature of study commissions that were charged with analyzing issues and developing proposals for the legislature. So you know, there's less of a risk of, you know, conflict or jurisdictional questions, I think.
Yeah, no, that's helpful. And that's all I had. Thank you so much again for the presentation and the answers to the question.
Thank you.
Hallie.
Sorry, always thinking of more questions. I'm in a policing in the 21st century class, and we're talking a lot about different technologies. So just kind of curious if the commission is dealing with surveillance technology, Fourth Amendment issues, if that's something that is really discussed, or if that's kind of out of your purview.
It's something that that we haven't gotten into, and I'm just trying to think if there's, you know, that as I mentioned, there was another commission created to deal with facial recognition technology, and that was a special commission. And then somebody reminded me in the chat that there was a provision in the statute, the larger session law dealing with facial recognition technology. I'm a little, I'm not as familiar with all the details on that. I'll just say that it was included in the larger session law. So that's, by the way, when I say that, I mean not the chapter of the general laws that governs our commission, but the, you know, the full extensive session law that addressed all sorts of different things. So yeah, so facial recognition was addressed in there, but I can't think of anything else that comes to mind.
Thank you.
Katie.
Yeah, my question is a little, might be silly, I think, but you know, my background's in housing and environmental, and so when you know, I kind of, as you're describing like the work that you're doing, you know, it sounds like the kind of full scope work, say, that like an environmental regulatory agency would perform over, you know, the, like, obviously in your case, like public actors rather than private actors, but like, you know, monitoring and regulating like a field, you know, establishing permitting criteria, like if that's like a reasonable analogy. But I guess my question within that is, does the commission have beyond certification and decertification, like prosecutorial authority in any way? Is that, or am I just kind of like, is there like a different, I guess, aside from the AG's office, which does have prosecutorial authority, like, is like, where do you fall within that space?
Right. We do not have the authority to bring criminal prosecutions. We do have the authority to refer matters to district attorneys or the attorney general's office for civil or criminal enforcement. And part of the reason that matters is that even it's an exception to that confidentiality provision that I mentioned earlier, which applies to preliminary investigations. There's an exception to our statute that says even during that phase that's normally confidential, has to be, that we can make a referral to a prosecuting authority, state or federal, for them to use it in a criminal prosecution.
So then is that kind, like that aspect, is that kind of comparable to like how a human rights commission might refer to a prosecuting authority?
You know, I'll tell you the thing that I'm more familiar with is there's similar powers given to other state agencies like our Inspector General's office in Massachusetts, which deals with waste, fraud, and abuse in government. And so what they can do is they can investigate. They can use various investigative powers to compel information from people and to basically put together a case, and then they essentially hand that case over to prosecutors. Now, it's still then up to the prosecutors whether to pursue it. They still have that discretion, but you know, I think that's similar to us in that we have subpoena power. We can subpoena documents or testimony. We can obtain documents from agencies. So we have a lot to be able to put a whole case together and then hand it over to a prosecutor if that's, you know, that seems appropriate.
Great, thank
I don't currently see any other hands raised. Any other additional questions? Oh, well, Randy, thank you. I know a few folks have already said it, but thank you so much for being with us today. I think this has been a really useful presentation and provided us with a great deal of information around how you've gotten started, some of your goals, as well as what you've already managed to accomplish since getting set up.
Thank you very much.
Yeah, so thank you
Well,
so much for being with us and sharing your expertise with the group.
Thank you. It's a pleasure. I really appreciate everyone's interest and insightful questions, and it's even generating thoughts for things that that we might want to look into more. So it's been a great experience. Thank you.
Fantastic. That's what we love to hear. Well, thank you. And for the fellows, thank you for being with us this evening. I will send a note with the link to the recording, but trust that it has already been uploaded to the form in the Dropbox, or sorry, in the Google folder. As well, next week we will be joined by, bear with me one second, I've been too hasty in closing my many tabs. Next week, we'll be joined by, I believe, Joe Cortez. Yes, Joseph Cortez with the International Association of Chiefs of Police. And he'll be talking to us about police education and training, giving us a bit more detail on the types of training that is received at the at the national level, as well as how it varies based on each individual agency. So if there is any recommended reading ahead of that, I'll be sure to send it to you with as much lead time as possible. In the meantime, should you have questions, comments, or concerns, please know that I stand by to address them. Enjoy the rest of your evening, and I'll look forward to seeing you next Monday.